Case number 2024 CR 509. Amber Norris appearing for the Butler County Attorney's Office. Chris O'Hara appearing as defense counsel. David Andrew Salter Jr. appears at the sheriff-operated Zoom location located at the Butler County Judicial Center in El Dorado. This is a somewhat unusual circumstance currently before the court. This matter comes before the court at this time for completion of sentencing. This matter came before the court for originally scheduled felony sentencing on July 21 of 2025. This court at that time did make a determination of a B criminal history score, heard a motion for departure, heard recommendations from counsel. The court addressed the defendant personally to allow him to make a statement. And then the court's recollection is that it began the felony sentencing in this case and did announce, and the court will now re-announce, an aggravated sentence of 20 months in Department of Corrections custody, 12 months post-release supervision is ordered, and 20% good time credit was found by the court to be appropriate. Before the sentence could be completed, Mr. Smith from Court Services did bring to the attention of the court that the defendant had a pending warrant to show cause hearing in Sedgwick County. It was related that that was going to be on August the 4th of 2025. At that time, the court made the determination to stop further sentencing proceedings at that time and postpone its ruling on the dispositional departure request until today's date, wherein the court was intended to complete sentencing, perhaps with knowledge of the eventual disposition of the Sedgwick County matter. Subsequent to our last hearing, defense counsel has filed a motion for continuance. Apparently, the Sedgwick County District Court has, for whatever reason, postponed the warrant to show cause proceeding over in Sedgwick County. The motion for continuance is essentially a request to further delay this Butler County sentencing completion until after Sedgwick County completes its warrant to show cause proceedings. The court has considered that request but declines to delay this sentencing any further. Part of the court's thought was that the Sedgwick County case was going to be heard relatively soon after the July 21 date. That's no longer the case. Further, the court is of the opinion that it should make its decision independently of any eventual disposition of the Sedgwick County warrant to show cause. So the court will proceed further at this time. I will, at this time, announce, or as the record may reflect, re-announce its rulings in regards to the other pending charges in this case. Regarding count 3, the battery of a law enforcement, a Class A person misdemeanor, the court does impose the standard sentence of 12 months in the Butler County Jail. Court imposes no fine on that count. On count 4, the driving while suspended count, a Class B non-person misdemeanor, the court will impose 3 months in the Butler County Jail, consecutive to count 3, but concurrent to count 1. So there is a 15-month jail sentence ran concurrently with the controlling 20 months Department of Corrections sentence in this case. Further, consistent with statute, the court imposes a $100 fine on count 4, which will be the only fine actually imposed in this case. All right, with sentence now completed as to each of the charges in this case, again, on the felony sentence, there was a 20-month sentence announced with a 20% good time credit allowance and 12 months post-release supervision. The remaining issue before the court is the court's eventual ruling on the motion for a dispositional departure in this case. Under the circumstances, I'm inclined to allow each party one more opportunity to address the court in regards to the dispositional departure request made in this case. Does the state have any additional remarks or arguments to make?
Your Honor, I don't think so. I was obviously not here for the last hearing. And I did have opportunity to review the evaluation from Higher Ground that was done on basically like July 17. I don't have any updates to that. So I don't know that I have anything further to give to the
Well,
court.
thank you, Ms. Norris. Mr. O'Hara, any further remarks or arguments to make at this time?
Your Honor, there's some update. Mr. Salter does have a full-time job, where he was just recently starting at King of Freight. He's attending AA and NA meetings. He's begun work on his continuing with his education as well. And he's been reporting to his probation officer in Sedgwick County. And I think he's also living at a rooted recovery halfway house or sober living environment. And he's doing, at this point, doing really well. He had gone through, I think, what started a lot of this for him, I think, and I think he spoke to Your Honor about that at the prior hearing, was a recent a death that he had in his family with his being his brother. And he's doing very, very well now. And we actually have other documentation if the court would like to see that. We didn't know how today was going to proceed, but we have other documentation I can have my office send you electronically that shows that he is in the Rooted Recovery Living Center, that shows he's got a job with King of Freight, and that one of his sponsors wrote a letter saying how well he's doing, how he's on the right path, and he's taking his recovery very seriously and taking the sobriety very seriously. If the court would like to see those, but we're just asking the court, give him an opportunity on probation. He's obviously somebody, Your Honor, that's fighting issues with substance abuse, and we're just asking that you give him an opportunity, and Your Honor, that the court, I guess, probably, I guess. I'm not exactly sure the recommendation from the state, but part of the agreement was at the time that and I don't know that he's violated that at this point, even with those other two pending probation violations, because nothing's been found on him. But we're asking the court give an opportunity of probation, which was what was negotiated by the parties. And I think even from this case here, there wasn't a significant, which is part of what I argued, I think previously, there wasn't a significant amount of harm that happened to the officer himself, and in this situation. And we think that an opportunity of probation for him is what he needs. And he's showing up, he's here in court. He obviously knows the court has the ability to put him in prison, and he's here to face the music. And I think the court has a significant amount of control over him. If he were to screw up, your court's going to know right away. And if he doesn't do what he says he can do, then the court would have the opportunity to put him in prison at another point. So we're just asking that the court give him a chance and place him on probation.
Since a lot of your request here for a departure sentence, which is an exception to the general rule, is based on substance abuse considerations, I just find it noteworthy that according to the criminal history, he hasn't had an alcohol or drug-related conviction for over 10 years now, though he has had some other offenses on his record, but none that are specifically for substance abuse-related problems. Also, I just find it interesting, Mr. O'Hara, that in your request for departure originally, you seem to suggest to the court that him being on probation over in Sedgwick County was a positive thing for this court to consider, yet you did not mention that he was facing proceedings for potential revocation of that probation at that time, which seems like somewhat of an overly convenient omission on the defense's part. I mean, yes, he may be technically still on probation in Sedgwick County, but he's facing further action on that sentence due to not just anything that's involved over here in Butler County, but some other allegations pending against him in Wichita and Sedgwick County. So is there anything you wanted to say about that?
Well, Your Honor, I mean, we didn't, I mean, the warrants that were I addressed previously, we were saying he was on probation at that time. I didn't have the warrants at the court that was brought to my attention when we were here. And I, the substance abuse has played a key part in that. Substance abuse was part of what his previous probation violation was for. And that was related to the circumstances of this. And that's what in part of what was addressed previously with the judge in Sedgwick County, not the warrants that are currently pending, but previous warrant that dealt with the case here in Butler County. And in that, it was revealed that he had significant amount of substance abuse issues. Now, the case itself that he had previously pending in Sedgwick County, we were not initially on the case, the underlying offense, but we were representing him on the PV hearing, on the first one. But Your Honor, we're no way is anybody trying to deceive the court. It's not trying to be an omission just out of convenience for the defendant. It was put on there. Just the reason why it was put on is because he's also got supervision there in Sedgwick County. At the time, he's on probation. And that's what Ms. Norris and I discussed the case. And that's one of the things we talked about is he was on probation there in Sedgwick County. And he had been violated for what this incident was there previously. And Your Honor, I think from what we've presented and what we have, and from the statements that Mr. Salters made to the court, it's clear he's got a substance abuse problem. And he admits that. And it's an ongoing problem for him. And the facts of this case, I mean, it indicate are of somebody that has a substance abuse issue. He's also got numerous thefts on his record. And I think a lot of this is traced back to what he has issues, which is our substance abuse issues. And if he can correct that, then I think that's what he needs to rehabilitate himself. It's not a stint in prison.
All right, Mr. O'Hara, his current Sedgwick County probation, for which he's currently facing further action, is based on a conviction of aggravated assault, is it not?
Yes.
Okay. And the conviction in the current case is for attempted aggravated assault, is it not?
Correct.
It would seem to the court that perhaps your client has an assault problem.
Your Honor, but in this situation, I mean, and that's what's clear from the reports. It's somebody, when they initially approached him at a traffic stop, he was passed out at the wheel of the car, and it was all substance abuse related.
All right. Either one of the attorneys have anything else to address the court about? Okay. Mr. Salter, though I've already given you this opportunity, I'm going to give you the final word personally. Is there anything that you would personally like to state to the court?
Yes, sir. I do have a substance abuse problem. Since our last my court hearing, I've got a sponsor. I'm working the steps. I'm in a sober living house, and I love being sober, man. I have a chance for my education right now that I'm getting ready to go. I'm working on my GED. I'm also working on Wichita Tech as well. There's a program here in Wichita that I love. I have a full-time job right now. I have a career right now that I've been praying for years. And I'm going to outpatient treatment as well, working on that trauma, working on, the death of my daughter, death of my brother. I'm working on all that trauma right now that caused me to keep relapsing, that caused me to use to numb that pain. I'm just, Your Honor, I would like the opportunity to show you that I can do this, that I can work on my substance abuse. I plan on staying to the sober living for at least a year. Yeah, I go to the NA meetings every day, actually. So guys from the house actually take us over there. So I love my house. I love being sober. I love my new life that's presented for me.
All right. Mr. O'Hara, you said you had some additional materials that you asked this court to consider.
Yes, Your Honor.
Okay, and outline for me again what it is that you'd be sending.
I have a letter from Cody Couch at Rooted Recovery, and it's just a letter to confirm that David Andrew Salter moved into the Rooted Recovery Sober Living House, and he moved in there on August 12th of 2025, which is at 906 North St. Paul in Wichita. I have sheets indicating that Mr. Salter had been, or a sheet indicating that Mr. Salter had attended AA and NA meetings, and it gives a date of August the 12th, August the 15th, August the 17th, I believe, August, and two on August the 20th. And I have a letter from a Krista Humphreys, which says, I'm writing this letter in support of Andrew Salter, who is currently in recovery and seeking continued residence in sober living. I had the privilege of knowing Andrew for 5 years, and I want to speak honestly about his character, his struggles, and his sincere efforts toward change. For many years, Andrew battled addiction, a disease that affected his health, relationships, and stability. Like many who suffered from substance use disorder, he found himself in a cycle he desperately wanted to escape, but simply couldn't find the way out. Despite the setbacks and challenges he has faced, I have seen a man who has not given up. What sets Andrew apart is his willingness to be honest about his past and his commitment to doing better with the support he knows he needs. Since entering sober living, I have witnessed a real change in him. He is showing up to meetings, to responsibilities, to his own healing. He is learning accountability, building healthy routines, and surrounding himself with people who encourage sobriety and growth. It is clear to me that he is taking this opportunity seriously. Andrew is not perfect, and he would be the first to admit that, but he's also not the man he was at the height of his addiction. He is someone striving every day to reclaim his life, repair relationships, build a future grounded in honesty and sobriety. Sober living offers him the structure, support, and stability he needs to stay on his path, and I believe this is critical to his continued progress. I wholeheartedly support Andrew's place in sober living and hope you will allow him the continued opportunity to grow in his environment. Please do not hesitate to contact me if you need additional information. Sincerely, Krista Humphreys. This is from a John Tapley. It's a message. It's a letter of an email or a screenshot of an email from John Tapley. To whom it may concern, I've known Andrew for a couple of years, 3 years. I've seen him help others, even online, with the recovery. I've seen him hold himself accountable and realize his part without blaming anyone else. He is one that would take his shirt off his back to help someone out. I'm asking the court in good faith to expunge his court and to give him chance to show he has learned from mistake. He always tried to help his fellow peers with guidance and with scripture. He's always praying with others to try to better himself, to be better and be better for others. Please hear my plea to the court. Sincerely, John Tapley. This is Jarrett Ryan, his sponsor.
Yeah.
It says, to whom it may concern, I'm writing this letter on behalf of Andrew Salter. My name is Jarrett Ryan, and I'm a member of the 12-Step Fellowship of Narcotics Anonymous. I have the privilege of sponsoring Andrew. He has been putting forth great effort to change his life. He is sincere in his efforts. He has begun to build a solid foundation in recovery. He is living in a recovery house and attending 12-step meetings. Every day that he stays clean, he continues to grow and change and establish himself as a productive member of society. It is with great hope that you will see the changes that he has already made and realize his true potential going forward. I look forward to continuing the work that he and I have started together, and I can't wait to watch him grow into the man he always was meant to be. Jarrett Ryan. And then it just shows that I have a letter indicating that, or a note, another email indicating that he is enrolled in school, and then another note indicating that he has a job at King of Freight.
When does he start that job, Mr. O'Hara?
Tuesday. Well,
It was supposed to be today, but he's starting tomorrow.
And you say that he was enrolled in school. What kind of school?
Can I say something?
It's the learning center in Valley Center, Kansas.
And what's the purpose of this course of study?
GD, sir.
Very well. The state have any additional remarks?
No, Your Honor, thank you.
Do you, Mr. O'Hara?
No, Your Honor.
Or you, Mr. Salter?
No, sir, I do not.
Mr. Salter, what your past history would indicate to the court that indeed, if your violent behavior is substance abuse related, if you relapse, you're going to be violent. So the court asks itself, what's different about this go round? Is it just because you don't want to go do a long prison sentence, perhaps for 2 different counties? Because this case runs consecutively to Sedgwick County 23 CR 1504, and that court has a warrant to show cause alleging any number of probation violations against you. I've seen the warrant. And of course, I can't predict what the outcome of the Sedgwick County case will be if it ever gets to court. But certainly you're facing prison potentially in 2 different courts right now. Is that just short-term motivation to do all of these things or set certain things in place to try to get you through court, where you'll then relapse, backslide, and go right back to the lifestyle you had before? Or does it represent real change?
Are you asking me? I'm sorry.
I am.
Oh yeah, sorry. Like I said, man, I have been really blessed with a really strong house right now that actually they care about us. I don't want to feel that pain and misery anymore. I don't want to feel like that anymore. I don't like that life. I can't stand that about myself anymore. I don't like that. I've obviously built a relationship with my fiance right now as well, that we were soon to get married. I love my life right now. I have a career. I have an opportunity for a good life right now, sir. And I have a career. I have school right now. And I can't stand that life. I can't stand that person I used to be. I can't. I don't like him. You know what I mean? And my sponsor helps me to kind of realize who I used to be and how much I don't like him anymore, and who I am today. And no, this is real change. It is. I'm like I said, I don't want to go back, man. I don't. And
Salter, it's not the court's concern who you are today, it's who you're going to be tomorrow.
right.
Because you've got an awful track record.
I know, man. I know. And it all has to do with substance abuse. Okay. And I just would like an opportunity to show the court, to show you that I can do this. You know what I mean? That I can actually work on this. You know, that I'm going to outpatient treatment, my meetings that I absolutely love. I love going to meetings. I love, helping people. I love seeing people succeed.
Salter, you deserve prison. However, sometimes in the court system, people aren't sentenced to what they deserve, but rather what's the most practical approach for the future. Mr. Salter, you've got one shot here. As it will be the ruling of this court to grant the dispositional departure sought by the defense. The court finding that the defendant's efforts and commitment toward rehabilitation merit an opportunity to be successful in a community-based program. And that community-based program will be probation supervised by community corrections for a period of up to 18 months. The defendant shall report to an officer as directed, observe all laws, participate in any alcohol-related treatment, aftercare, or recommended sober living situation that his providers do recommend for him. Failure to meet those conditions very well would be considered substantial material violations of the terms and conditions of his community corrections probation. He shall not possess or consume alcohol or illegal drugs. At his supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing. Perform any community service work pursuant to any program requirements. And this court has actually opened, Mr. Salter, to you performing some of that community service work in a sober living and or treatment environment.
Okay.
Should that program wish to supervise it. Maybe your story can be helpful to someone else.
Absolutely. Yeah.
Shall
Yes.
gain and maintain employment suitably throughout your probationary term. Notify your supervising officer within 24 hours of any change in employment, residence, telephone number, or email address. You shall have no contact with the victim. Let's identify that victim by name, Ms. Norris. And I trust that would be the officer that was involved.
Yes, Your Honor, that was Sergeant Troy Snedeker.
Okay. Well, Mr. Salter, you should have no occasion to be encountering any law enforcement officers
Okay.
once you're out on the streets.
Yes, sir.
You shall abide by any curfew or travel restrictions associated with community corrections programming. Report, again, as directed to your supervising officer. And community corrections is authorized to require the defendant to meaningfully participate in the MRT program. Defendant is assessed a felony docket fee, felony probation fee, community corrections fee. Counsel is retained, so there'll be no biz assessments. Want regular and consistent effort made on your obligations here, Mr. Salter, beginning with $75 a month in the month of September and every subsequent month until your case is paid in full.
Yes, sir.
Ms. Norris, are you aware of any other court costs which this court should consider?
I don't believe so, Your Honor. Thank
Okay.
you.
Regarding the issue of jail time, this court certainly contemplated just locking you down for almost 2 months, Mr. Salter, but I really don't want to interfere with anything good that you've started. And frankly, if you're not going to stay in the programs that you've told the program about, there's no point to you being on probation.
Right. Right.
Court will grant the defendant 9 days of previous jail time credit, but release him on to community corrections at this time.
Thank you.
Some point in the future, Mr. Salter, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. Under some circumstances, a criminal defendant after sentencing has the right to appeal their conviction to an appellate court having jurisdiction. And if a defendant is unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, Mr. Salter, you have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, are you aware of any sentencing-related matters that still need to be taken up?
No, Your Honor, thank you.
Mr. O'Hara, are you?
No.
Mr. Salter, do you have any questions about the court sentencing orders?
No, sir.
All
Thank you,
right,
sir.
I have Christy Ashenfelter here from the Community Corrections Department of Butler County. We're going to leave this Zoom meeting open for a few minutes for you to have a discussion with her. Your attorney certainly can participate if he wants. She's just going to try to get you started on the Community Corrections Program. Follow her directions as
Yes,
to
sir.
what you need to do next on this program.
Yes, sir.
Mr. Salter, I truly hope that I don't have to review this sentence in the future.
Okay.
I
Yes,
think
sir.
your attorney might give you advice as to what that likely outcome will be if you come back to court. So you got to make this work.
Yes, sir. Thank you.
Very well. Christy, I'm going to go ahead and leave the meeting open. If you'll meet with Mr. Salter, give him appropriate direction.
Later.